Hi, everyone. This is Adam Walker Miller Johnson. For today's 5-minute message, I'm going to say a bit about the recent Oxford Schools decision involving governmental immunity. After the tragedy at Oxford High School, a number of court actions popped up. Some of those were criminal, which won't be today's focus. But we will say a bit about a civil lawsuit brought by family members of some of the victims. Among the defendants were the school district itself, as well as some of the district staff. Now, as we all probably know, the government hates to be sued, right? I say that as if anybody likes to be sued, but anyway, because the government makes the rules, it makes it hard for people to sue public entities and their employees who are acting in the course of employment. But in Michigan, public employees can be sued if they were grossly negligent, among a few other requirements, which we'll get to in a minute. So basically here, plaintiffs claim that the school district and its employees were grossly negligent, and separately that they failed to meet their duties as mandatory reporters. They lost. The school and staff asked the judge to kick the case out of court, and the judge agreed. Why? Well, for a school, there are generally 6 exceptions that get around immunity for public entities. And none of those exceptions applied here, and none of the other sort of exceptions that aren't expressly in the statute, your civil rights things, none of those were present here either, right? So for the staff, gross negligence is only part of the story, though, right? To get around governmental immunity, the staff member has to have been what's called the proximate cause of the harm done. Proximate just means that something is the one most immediate, efficient, and direct cause of the injury. Now, the plaintiffs argued that there was an open question as to what the proximate cause of the injuries were here. But obviously, the judge said that's nonsense. The person who brought a gun to school and shot others is the proximate cause, that meaning the immediate, efficient, and the most immediate, efficient, and direct cause of the injury. Obviously, it wasn't the staff, even if they were, for the sake of argument, grossly negligent. The judge said that was a non-starter, essentially. Now, of course, this decision can be appealed to a court higher up. But for now, the bottom line is that school districts and their staff still have plenty strong protections under governmental immunity. And that's true even if people didn't act perfectly. It's true even if, and this is not my personal commentary on how the employees acted here, but it's true that even if they acted pretty stupidly, governmental immunity would apply, at least to some extent, right? So regardless, there have been some recent decisions that make it a bit easier to create a dispute about proximate cause and poke holes in government liability. And we'll have to see how those are applied to the situation if this decision, is really given a pretty strong review on appeal. So we'll essentially have to wait and see if there's anything noteworthy that happens at the appellate level. In the meantime, stay tuned. We'll provide any updates if there's anything noteworthy that comes out. Thank you all for tuning in to this quick 5-minute message. We'll see you next time.